Sorry for the delay again tonight. Item 1 is approval of the report from the August 5th, 2019 Planning Commission meeting. Commissioners, what are your wishes regarding that item?
Motion to approve.
We have a motion by Tao. Is there a second?
Second.
Second by Wesley. Any additions or corrections to the report? Hearing none, moving to a vote. All in favor, signal by saying aye.
Aye.
Any opposed? Motion carried unanimously. Item 2, Plan 190938, Community Development. The applicant is requesting adoption of a new sign ordinance, Chapter 46 of the Municipal Code, to replace the current version. Adam,
All right.
turn it over to you.
Obviously, you guys have seen this a number of times. We did have our public hearing in the month of September. Yes, September. At that, we had a couple people from the community show up. More clarification questions. There weren't any major concerns that were raised during the open house that we held on it. After that, I just did a final read-through. So there are some changes on the document that is before you tonight. So I did leave the corrections setting on, so hopefully you can tell. A lot of it was just little typos, in is where it didn't need to be, that type of thing. I would say the only major changes or questions I had on the actual table, which is the 11 by 17 if you have the packet I sent out, otherwise it should just be the last page of the document. If you remember, that's basically where the size and location regulations are. In reading through it, I noticed that there wasn't a maximum size for the ground signs in institutional, recreation, or the manufacturing districts. So I did recommend that those be put in there, just so technically if you have a large industrial site and it's just based on the frontage, you could end up with a very, very large sign, which I thought was probably against the intent of what you guys were going for. So in institutional, I recommended a 100 square foot sign being the maximum. Park and Rec, I recommended 60 square feet, which is similar to the B5 district, which is kind of your office district. The 100 square feet of institutional is the same as the B3, which is the neighborhood commercial, so where you have a little smaller scale. And then industrial districts, I recommended 200 square feet, which is the same as your general commercial district. So they weren't just numbers picked at random. So I tried to be consistent on that. And then the major question I had, or clarification I asked of the consultant, was just regarding the temporary signs in commercial districts. If you remember, at the last meeting with the consultant, there was a discussion on do we want to specifically prohibit certain types of temporary signs or not. Ultimately, the discussion at the commission was no, to take those specific restrictions out. And then there is the section, it is on page 10 of the document, I believe. Oh, no, I'm sorry, page 11, section 46.23. So signs allowed with a permit in a non-residential zoning district. Basically, outside of your typical freestanding sign and your wall signs, which are dealt with in that table, this section says, besides that, you're allowed up to 24 square feet of signage. And that's kind of an open book, however you want to deal with it. That can be an election sign, that can be a flag sign saying open, now hiring, that can be your special event sign, whatever that may be. And it's just that 24 square feet. It is something that would require a permit. In talking with the consultants, their thought is basically business comes in the first time, they're going to put up that supplemental signage, get a permit at that time, and then as long as they're complying with that 24 square feet, that permit covers it. It's not something that every time they change the election sign or something like that, you wouldn't be coming in repeatedly. It's just you get a permit basically to access that additional 24 square feet. So I just wanted to clarify that and make sure that that was clear to everyone here.
So they have to get a permit for, and currently there's not a requirement.
Currently it's for temporary signage or special event signage, it's a $15 permit, and that allows those limited engagement ones. So that's 15 days up to 4 times per year. This one basically says it can be year-round, that you don't have to take them up, take them down. It's just that supplemental 24 square feet. That was really the only clarification question I had as I read through the entire document. I just wanted to make sure I was fully understanding that and able to explain it to you guys. Otherwise, it's pretty much as you last saw it.
On that point yet, on the supplemental, the last statement in there, signage indicating the property is for sale, rent, or lease. So we are requiring someone to pull a permit for.
Yeah, and again, it's not necessarily for that sign, it's to access the supplemental. So what the permit is for is so that you learn what this regulation is.
Okay.
So you think of it as a one-time permit. So it could be for when it's for sale, it could be the first time they have a special event, whatever that may be, but one time they get a permit, get these regulations, and then from that point forward, they can do whatever they want, as long as it complies with this. Does that make sense? Oh yeah, that was my concern. We're gonna require someone to get a permit every time they're changing a for sale sign or a lease sign. No, that's not the intent.
So
One-time supplemental signage sign permit.
And that includes free speech, election signs.
In the non-residential, in the commercial districts. In your residential district, that's the previous page, the 46.22, signs not requiring a permit. That's where they're allowed up to 24 square feet of whatever signage they want in residential districts. So again, that can be for sale, that can be election sign, that can be a sign that says, I like pink. It doesn't really matter what it is. So that one would not require a permit in the residential, only in the non-residential.
Okay.
So commercial and then industrial, basically.
Murals. Obviously, we just had a request from the community on that topic. What process? I mean, I guess the concern I have, based upon your interpretation, or maybe that was under the old code, around the total square footage, that it actually counts against because they're treated as a wall sign, right? So that counts against the business's total allocation.
Correct. Yeah, so page 3 of the code, the third from the bottom is the definition of mural. It says see wall sign. So that's why I interpreted that it's a wall sign. I was thinking about that a little bit. So yeah, unfortunately, if someone paints a mural on the side of a building, that's technically taken away from what other wall signage or overall signage they can have. An alternative, I don't think you'd want necessarily a variance, because you can't really prove a hardship because you want a mural. Something that we had incorporated into the zoning code is something called a special exemption. So it's something where they come before the plan commission for an exemption to the code, and it's not something where you have to prove a hardship. It's really just a review process. You could do it that way, or you could do a conditional use would be the other option, and that would have to go through a public hearing here and then approval by the council. This kind of depends on if you want to take it outside of your typical sign regulations. Those would be some options.
Any thoughts, commissioners, on that? There's just something that I think a little concerned about whether or not there's going to be enough space or allocation in the kind of overall picture if somebody's going to do like a downtown mural on a side of a building or something like that. I mean, I think administratively it makes sense to treat it as a wall sign, but...
And I guess a third option would be if you want to still be able to control the size of a mural, meaning you don't want a small commercial lot that has a 300 square foot mural on it, you can tie the calculations to the wall sign calcs, meaning, for example, in downtown, I believe it's 2 square feet per length of the facade that it's on. So if it's a 100-foot long wall, you're allowed a 200 square foot wall sign. You could still say that's your calculation for the mural, but it does not cost, or it doesn't count against your other allowable wall signage or all other allowable signs. So that's still your way to control the size. Takes any plan commission, it's still a staff review as long as it meets that wall sign requirement, and then you're not penalizing them for supporting the arts or the whatever community messaging. However, I would say in that case, the mural should be a non-commercial content. If you're going to have a mural that then at the bottom says sponsored by Wood Trust Bank or whatever, that Wood Trust Bank portion, that is a sign. They're getting exposure for that. But the picture of kids playing in the park, that isn't a commercial message. So it gets a little gray if you're going to do it that way.
Okay. So there's a couple of options available to us. Commissioners, any thoughts on that? Anybody concerns? Joe?
Well, I'll just mention, I do think that there is benefit to having murals, or there can be. I do think they should be regulated. And I think, Adam, your first mention as far as regulating that was it was a special exception.
Correct.
Not a conditional use. And I think that makes sense over a conditional use, because a conditional use, essentially you have to grant. Special exception, you don't.
It's discretionary.
Right. That a special exception with those limitations, I think makes good sense. Allows the community to, well, the commission anyway, to do a review and make sure that it makes sense, that it's a fit, and if they don't like that, there's still an administrative appeal process, correct? That someone could still appeal through the
Basically, appeal
standard.
to the council.
Right.
Sure. Commissioners? Thoughts?
No, just back to the first point, if there was a non-residential business that wanted to put up a free speech sign or something like that, they potentially would have to draw a permit first?
The initial time, correct.
And there's no, I guess, issues with that legally? Like, we're not
Right.
prohibiting free speech.
Right, because the way the code is it's not talking about the content of that sign, it's just supplemental signage. It's
Okay.
signage above and beyond what you would normally be allowed. So
Okay.
basically, you're getting a permit for that signage above and beyond. If it's signage that already meets your typical freestanding or wall signage, it's a typical sign process. So it's content neutral, that's what you have to do. You can't say a real estate sign has to get a permit. You can't say versus an election sign. That's what you can do, but if it's just generically signage above and beyond, that's what you're getting the permit
Okay.
for. At least that's my understanding of how they're trying to interpret the Supreme Court decision.
I'm just, semantics, trying to think through, so the permit is for existence, so the sign can exist, basically.
Right.
And
In a
it has
way,
to be
this-
rolled initially.
Yeah, sorry. In a way, the sign permit is basically, it's a way to collect their signatures so that they know what the regulations are. If you want to think of it that way. It's the way to get the business in so that you can say, these are the regulations you have to play by, versus them just doing it willy-nilly or doing whatever they want.
And it's, what, $15?
Currently, the fee for that is set at 15, right? So it's a relatively low cost.
In some ways, I'm wondering if this is gonna if this would come back to the commission at some point in the future. I mean, I completely understand administratively in that process.
Yeah, the alternative would be to move it from requiring a permit to the section of signs not requiring a permit.
I guess I don't have a problem with it, I don't think. Just thinking where is it gonna be administratively difficult or onerous for a business or commercial property? I shouldn't even just say a business, because it could be anything commercial.
And if it's a one-time issue, businesses change hands. If it's a one-time issue and it's permanent thereafter, it might not be really beneficial for the business. Especially if I come in and buy a new business and this address had a permit, I wouldn't necessarily know then that, well, I can still do this. It seems that maybe there should be some limitation on that permit, that it's at least to that business owner, a new business owner, new property owner would have to reapply. Again, it's a nominal fee, but
How does that work with the continuation of permits? Is it to the property owner
it's to the property.
or is it to the signs?
in the case of signs, it's generally towards the sign itself. Like a building permit it's to the property generally, obviously. If you sell a building, the building doesn't have to get re-permitted.
Right.
This one's a little gray because it's not, again, for a specific sign that you're getting the permit. It's to access the supplemental signage is what you're getting. So I guess I don't know the answer to that. Language probably could be added that it's specific to a business, and if the business changes hands, then the permit must be obtained or something to that effect. This is my first time dealing with this concept of it, so I apologize. I don't necessarily have the best answer on it.
I think the election component's gonna be dicey, right? Because who's gonna pay, but I guess if they get their access to the supplemental one time, they've got it. Yeah, I don't know.
Because then if it's permitted, if they're not in compliance, you don't have to mess around with a lot of notices of non-compliance, things like that. I mean, you do, but
Initially.
you don't have to necessarily give it a lot of time.
Yeah.
Look, you're in non-compliance, you got 24 hours to fix it. You knew this because you applied for and received a permit. Versus someone that just literally didn't know because it's something different.
I don't intend to dwell on it, I just try to think through, practically speaking. Other thoughts?
Wouldn't you think that it would not stay with the owner of the business that applied for it and received the permit? If he were to sell, the new owner should have to get it. Yeah, and that's what it's,
Permit.
right.
I don't think it should stay with the property, it should stay with the owner.
Right.
And if it changes hands, then
They
it would
have to-
make more sense for them to reapply.
Tied to the business
Yeah.
versus not necessarily even the owner.
Yeah.
If it's a Little Caesars now and a different owner buys it and it's still Little Caesars, I guess in my mind that
That would
stays
be the
with
state,
it. It's,
the same.
it's if Little Caesars sells to a completely different,
Yeah, there's a complete change in use. Yeah.
something like that. You can play around with some language to float, if that is the desire. And then on the mural, any decisions, or do you guys want to chew on it for another month, or?
No.
'Cause I'm fine with that.
No. So I think
the way it's
if
written
we
that
talked
now
through
is
that
fine. Yes.
idea of that special request, would you
Special
call it?
exemption.
Special exemption, but that's not the way it's written though, right? It's
Correct, that would be, I can tweak the language. Basically, what I would do is murals, and then I would change this definition of mural. I would say size is basically based upon, is the same calculation as wall sign, however, it does not impact the allowable wall signage and is subject to special exemption.
Is that
As
what
outlined
folks
in-
support?
If that's the case, I've drafted something to try.
Okay.
Would be a motion to approve the plan, including a provision to allow non-commercial murals as a special exception with the same limitations as a wall sign. And supplemental signage under this 46.23 continues as long as the property owner continues to own the property. Does that sound?
Or is it use? Change in use. Because you were just using the pizza example,
Right.
Little Caesars example. Like Applebee's has sold
Right.
like 3 times now
Right.
in the last period of time. So if they got a supplemental sign permit,
Yeah.
Or change in use, and that way
Yeah,
it wouldn't be and, it'd be or.
And or, yeah. I think that's fine, quite honestly, from an enforcement standpoint. If the officer is driving by Applebee's and it's still Applebee's, they're not gonna stop and say, do you have your new supplemental signage? So
Right,
I think
right.
de facto, it's gonna end up being a change in use. Or
Well, yeah,
it's
it's
not
on a
really gonna
complaint
be.
basis anyway, that's the
Right.
only time you're gonna be addressing that, most likely.
Most likely, yes. And then the one thing I would say on the mural language that you have, Joe, is I think if I understood the conversation earlier, it's that you don't want to take away from other allowable wall signage.
Yeah, right.
So it's a special exemption with the same limitations as wall signage, but I guess I have to kind of get my head around how to phrase that
All you'd
next
have
part, that it
to, all you'd
doesn't.
have to do is redo the, I think that's okay though, including a provision to allow non-commercial murals as a special exception, so that's in the definitions,
Mhm.
with the same limitations as a wall sign. It's separate, but with the same limitations as a wall sign.
Okay. All right, I think I can draft up something in an ordinance and get it to council. If that is the motion you wish to pursue.
Other areas of discussion or concerns? Anybody? We haven't received any comment besides the open house. There wasn't anybody that followed up with any written comment or anything. Okay, correct. Very good. Just wanted to make sure we didn't have to read that into the record. Okay.
Then I will make a motion to quote exactly what Joe Terry said.
Is there a second?
I second.
Second by Tal. Any further discussion? Hearing none, moving to a vote. All in favor, signify by saying aye.
Aye.
Aye. Any opposed? The ayes have it. Thank you for the conclusion on that recommendation to the city council. It's next Tuesday's meeting. Entertain a motion to adjourn.
Second then. Oh,
I'll make a motion. I'll put a motion.
Aye.
Tal, second. All right. All in favor?
That's too quick
Aye.
to pick that up.
We stand adjourned at 4:50.